respect to the, let me just summarize the Administrative Office of the Court's order, because some of the things that the chairman have said are not quite accurate. First of all, it was standard operating procedure not to disclose the names associated with toll records when the toll records were sought by the government under DOJ's, both Democrat and Republican. In fact, it was the Trump 1 DOJ that did this with respect to House members. And it was the Biden DOJ that fixed this problem to require that the disclosure now be made. And the suggestion that the basis for the need for a non-disclosure order would be the conduct of the recipient of the person whose toll records were obtained has been fairly well rebutted by Jack Smith in his sworn testimony in the House, where he pointed out that the basis for that order was the pattern and practice of Trump associates putting improper pressure to bear to intimidate witnesses over and over and over again. The fault lay in the conspiracy, not in the subjects of the toll records request. Professor Vladeck, we've talked, I think there's a pretty good fault line here between adjudicative decisions, whose remedy is appeal, and personal or administrative misconduct that traditionally forms the basis for an impeachment. On which side of that line would the failure to declare or pay personal income taxes fall?
Yeah, I mean, I think it's certainly on the personal off-the-bench side of that, Senator.
Yeah, that would be personal misconduct of the kind that impeachment would likely cover. And we still don't know the answers to those questions, which to me is quite surprising. Is it not also true that regular citizens have been prosecuted and convicted for failing to report income and pay associated taxes?
Fairly regularly, to my understanding, Senator.
Yeah. And if we look at this question of threats, which is the context for a great deal of what we're hearing today, it appears to me, and it appears to judges who've spoken out to this effect, that there is a pattern of threat, an unprecedented pattern of threat that has arisen during this administration with, as you point out, judges who've been appointed by all presidents who have surviving appointees. And it's not just the threat that's part of it. It's also what the judges are saying about the Department of Justice and its lawyers. So back to the MAGA DOJ, just summarizing some of the words that have been used about their arguments and behavior in court: disingenuous arguments 5 times, bad faith arguments 5 times, unprecedented behavior including, quote, concerted effort by the executive to smear and impugn individual judges who rule against it, being both unprecedented and unfortunate. That's a Trump appointee speaking about this administration's behavior. Shoddy work 3 times. DOJ losing credibility or being disrespectful, having lied. Willful and intentional noncompliance with orders. Pretexts being offered. Unconscionable arguments. Nonsensical arguments. In that environment, what then comes into play is, I'll let you pick it up from here. How many senior people in the administration have made threats against judges, both generally and specifically, from the president on down, when they make a decision disagreeing with them?
I mean, the number I can think of is 5, Senator, but that's, there's probably more. That's just what has been widely reported. And I think, I mean, it's worth stressing that the point, including the president, and it's worth stressing that the point is Stephen Miller, the Attorney General, the Deputy Attorney General, the then Chief of Staff of the Justice Department, Chad Mizell. And I think it's worth stressing that the point here is not that it is never appropriate for the executive branch to raise concerns about federal judges. The point is that there are processes for those concerns. And so I'm just struck that here we are, more than an hour into the hearing, and this is going to be the first mention of the Judicial Conduct and Disability Act of 1980, which Congress passed largely to recognize the fact that it was a impossible choice to have nothing or impeachment as the options for judges misbehaving. There is a JC&D process. If there were actually serious charges to be brought against these judges, that would be the avenue. It hasn't been utilized except for the frivolous complaints against Chief Judge Boasberg.
Precisely. And I would argue that the context here is a pattern of threats against federal judges for unprecedentedly bad behavior by DOJ. When they call it out, they then have the cascade of threats fall in on them, and that it's a deliberate effort to try to intimidate the judiciary into not ruling against the Trump administration, no matter how defective the position that they take. And it's hard for me not to see this proceeding as supportive of that unfortunate effort.